Ready, start. Further, from a plain reading of Rule 9 of the rule, it is clear that in the first place, under Rule 9, within bracket 1, the petitioner is entitled to claim all amounts representing the value of service and labor and profit thereon by way of deduction stop. The deduction is thus allowable in entirety subject of course to its due verification without any limit or restriction to a percentage or proportion to the amount received or receivable against the work contracts in respect of which such a deduction is claimed stop. However, another method for computation of such deduction is provided under Rule 9 within bracket 3 of the rules stop. It is subject in its application to three alternate preconditions, one of which must be found attracted before the method of computation of deduction of value of labor and service and profit thereon may be applied stop. Read together normally under Rule 9 within bracket 1, deduction on account of value of labor and service and profit thereon is to be allowed at actual figures claimed by any assessee stop. However, a rule of exception is contained in Rule 9 within bracket 3 which comes into play either if the assessee does not show separately the value of labor and service and amount of profit accrued on such labor and service or the accounts maintained by the assessee are not worthy or of credence or if the assessee does not maintain any accounts stop. Plainly, Rule 9 within bracket 1 and Rule 9 within bracket 3 cannot and they do not apply or operate simultaneously. Rather, Rule 9 within bracket 3 applies only if application of Rule 9 within bracket 1 is excluded on account of presence of any of the three preconditions mentioned in Rule 9 within bracket 3 stop para. Here, in this case, no information, material or fact or reason has been recorded to establish the satisfaction of any of the three preconditions of the applicability in Rule 9 within bracket 3 in as much as it has been alleged by the assessing authority in the region to believe recorded by him that the petitioner had not maintained its books of account or that they were not worthy of credence stop. On the contrary, while the reason to believe recorded by the petitioner's assessing authority is absolutely silent on this issue in the original assessment order dated 30th April 2013, it had been categorically recorded by the petitioner's assessing authority that the books of account had been maintained by the assessee and the same had been examined by him whereafter a finding was recorded by him as to figure of sale of steel and cement stock. In addition thereto, the assessing authority, while making the original assessment order, had also examined the contract documents, especially in respect of payments to be made therein, and observed that payments for labor, charges, and supplies were provided to be made separately. Stop. Thus, the third alternate condition for application of Rule 9 within bracket 3 of the rules clearly and admittedly does not exist. That is, it cannot be alleged that the petitioner had not maintained the books of account